So, all the participants kindly mute your video as well as audio. Let's start. So, good evening to all. This is Suresh. I welcome all of you in the listpiece.com Madras Library Association webinar series 2. Today, our resource person, Dr. R. Rajavardhanan, Assistant Professor, Government Law College, Trichy. He is specialist in business law. He already resource person in the reputed institution like NIT. He delivered lecture on the topic of IPR. Today he going to deliver a topic on IPR for library and librarians. He is a multi-talented person. He can speak more than 6 Indian languages. So you can comfortable to asking question with your own language. He may answer your own language. So once again, I welcome you, sir, on behalf of Diskis.com and Madras Library Association. Let's hand over section to Rajavardhanan, sir. Sir.
Respected learned colleagues, students of library science, and professors and other distinguished members, it is my privilege to sit before you and give a small orientation regarding what is intellectual property law and how come this intellectual property law is associated with the library science, and why is that the library science department or the library science institutions need to focus upon the importance of intellectual property law. Now, before I move on to the topic, I can comfortably say that most of the participants here are from non-law background. So I'll be making this very basic so that you all can have a basic understanding of what is intellectual property law. Now, intellectual property law is basically a right which is given to any origination that comes from human mind. And it is broadly divided into 3 major categories, that is copyright, patent, and trademark. And there are allied IP laws such as the geographical indication, the designs law, semiconductor layout, and integrated circuits act, varieties act, and the biodiversity act, and so on. We have n number of many statutes which are protecting the intellectual property law. But the primary 3 are the copyright, trademark, and patent. Now, copyright is the oldest and the foremost of all the intellectual property law. The reason is because earlier man, even though man invented many things, of course, invention comes first, then only comes the copyright, that's the literary aspect. But once the invention came, man did not have the thought of copying it. I mean, man did not have the idea of patenting it. So first came the origination of intellectual property, first of all came with the literary work, because at a point of time when man the human mankind needed some form of entertainment, that was writing stories, making dramas, plays, and writing poems. So all of this helped and structured a human mankind. So at that point, what happened? That need for registering those ideas in a tangible form, so that is copyright. So copyright is basically awarded to any literary, artistic, dramatic, artistic craftsmanship, then literary, dramatic, artistic craftsmanship, musical, sound recording, and cinematographic films. All for this section we give copyright protection. Now moving on, see, I'm not taking much time into discussing all, because I am going to focus more upon how library science is associated with intellectual property. Now the second area is the trademark law. Trademark law is basically given to any marketing agenda or any, it may be a word, it may be a symbol, it may be a color, combination of word, it may be a slogan, it may be shape, color, smell, everything can come as a trademark is basically given to any product or that is augmenting market. So if any product is going to be augmented in the market, that needs advertisement. So all advertisement also comes under the category of trademark. Now trademark and is second category of intellectual property. Third one will be the patent. Patent is given for all inventions. So we need to be very clear that discovery is different from invention. Discovery is finding something which is already been there. Invention is that you are creating something which is never known to mankind. For example, let me say something, fountain pen. The pen first of all created was never known to mankind. How did man used to write in papers? Earlier, okay, of course, paper was not there, so leather was one of the medium. And if we find in Tamil Nadu, you will find that palm leaves, ovali chavadigal. In that we used to write. And what are the mode? Achani. Achani means for example a needle. Only needle was used to write in the palm leaves, and dyeing was done later. Then what happened in leather? Leather, the peacock's feather was used as a pen. And later on, then when William Penn brought out the concept of fountain pen, that was a groundbreaking invention, which helped in giving that pen was very helpful in writing. Now that is an invention which was never known to mankind. So this is so invention. For any invention, when a right is given, that is known as patent. So patent, copyright, trademark. These are the primary areas of intellectual property. Of course, we have the geographic indication, which is given to any product that is originated from geographic area like Banaras silk, the Silau Khaja, and Bengal Rasgulla. These are all examples of geographic indication. I'm not going very deep into that. Now let us come to the main aspect, that is IPR for librarians and library. Right. The only one area which I am going to cover today is the copyright law, because only the copyright law focus on one primary area of library, that is known as reprography. Okay. I hope you are all aware of what is reprography, and there is especially when I go to library, I find a small section known as reprographic section where most of the photocopies are made. Now, when we speak about reprography, before I move on to what is reprography and the allied laws related to that, I should concentrate on the international law first of all. So the Berne Convention, also known as the Paris Act, this Paris Act came in the year 1971. So this 1971 Act, Paris Act, in that the Article 9 of the Berne Convention gave exclusive rights to reproduce. Now, before I move on to what is reprography, what is reproductive rights, I should say what is the rights that the author derive in a copyright. Assuming if I am there, if I write a book, okay, for example, the development of library science in India, if I write a book on this topic, right, now I am the sole owner of the book. Only I have the right to publish the book. So first right that is given to me by the Copyright Act is the right to use. Second, right to publish, right to make copies. These are the right to assignment, right to license. These are all allied rights. Primary right is right to use. Only I have the right to use the product as of my own choice. Now, when we come to the moral rights include some rights like right against defamation. If suppose tomorrow somebody writes upon my book, as this is one of the crappy books found anywhere in India, this book has no substantial value. This book cannot be treated as a good book. It is waste of time. If somebody writes like that, it affects my moral right. Now, moral right is also given under the copyright law. So nobody can defame me upon what I wrote. So that is not allowed. Movie spoofing and all as new aspect which has come recently. So I am not going to go deep upon that. So Article 9 of the Berne Convention gives exclusive rights to reproduce. Now, exclusive right to reproduce lies only with the author. Only I have the right to reproduce as number of books I want. Now that I can do by giving it by license or assign them to some other person. For example, I have say Hari of printers or Hari publishers. I give my right, the origin and development of library science in India. I give this book to Hari printers, Hari publishers to publish. Then he is the exclusive licensee to publish my book. So only he has the right to reproduce. No one else has the right to reproduce. Fine. Now this Article 9 Clause 2, this 9 Clause 2 of the Berne Convention of the Paris Act, it gives a clear example or clear structure as to how this reproduction should be done. There are two exceptions which are given. Okay, before I move on to the two exceptions, I should state that this Article 9 Clause 2 of the Berne Convention gives the right to the particular nation. For example, the Berne Convention gives rights to Indian law to make law in such a tune that this reproduction rights does not affect the author's moral right. Now, these two exceptions which are given in the Article 2 is first one, permitting reproduction must not contribute to the normal exploitation of the work. Now, when we come to the concept of reprography, the right of reproduction. The right of reproduction solely rests with the author, but in some cases, some circumstances, the right to reproduction can be done by other person also. For example, if I want to use a book for my own purpose, I can go borrow the book from my friend, take photocopy of the book and keep with me. For example, the price of the book is 1,000 rupees. I have photocopied the book for 100 rupees. There is a 900 rupee loss to the original author. Where if I want to have the book, I would have purchased the book from the shop. Now, by not purchasing the book in the shop, I have cost 900 rupees loss to the original publisher. Now, in that circumstances, that is what Article 9 Clause 2 says, that for personal use, reproduction can be done. Second one, the reproduction must not unreasonably prejudice the legitimate interest of the author. So that is the legitimate interest is that money making. So I cannot say purchase get a book from my friend, make 20 copies, sell those books to others. That is not allowed. I will, in those circumstances, that will not be treated as a fair use. So of course I'll come to what is fair use under Copyright Act, so that you will get a better understanding of reprography. But Article 9 Clause 2 of the Berne Convention and the Paris Act clearly states that all nations, all the signatory nations of the Berne Convention have right to prepare their own detailed structure of the copyright law in regarding reprography, and these two exceptions should be given. That is for personal use, and that is for not prejudicing the legitimate interest of the author. Right. Now, I should also, as I already discussed about what is moral rights, I'm not going to go deep into that. Let me come to one area, that is private copying, that is in the United States Copyright Act 1976. The US Copyright Act 1976 clearly details about what is private copying. Private copying is for private use, that is personal use. So personal use in the sense does not mean only singular, it can be plural as well. I can copy I can photocopy a book and use it for my family members. I can circulate to my friend for for study purpose, for reference purpose. That is allowed. So private copying is allowed under the US Copyright Act for unlimited classroom access. If suppose tomorrow you are going to take class to your students on library science, you have the right to take a book, make 40 copies and give to your students. That you can do. But you cannot profit from such an act. If suppose decides to take class on library science, and what say he takes 100 copies of a book, hmm? And the price of the book is 400 rupees. The price of the book is 400 rupees, and he photocopies for 50 rupees, and if he sells that for 100 rupees, now he had made a 50 rupees of profit per book. So into 100, say 5,000. Now 5,000 is a profit which Mr. Suresh has derived by selling the book in the class. That is not allowed. So unlimited classroom access can be given. So what happens is you can photocopy the book and distribute among the students for free of cost, or for the nominal price, that is photocopying price, that is allowed. So unlimited classroom activity access is allowed for private copying, that is allowed. Then library photocopying. Now, this is where I'm being very clear. In US copyright law, there has been mentioned that in libraries where reprographic section is there, clear instruction has to be given that any copyright violation, the library is not responsible, because you have to give a saving clause. If there is no saving clause, what happens is that the librarians will be held responsible. The library will be held responsible for breach of any copyright. So that should not be done. So that is what the US copyright law clearly states, that unauthorized copying and permission for replacement. For example, uh, permission for replacement. If suppose there is a book and the book is in very wear and tear, it's gone through much of wear and tear, and it's a very decapacitated situation. In those circumstances, the librarian has a right to take a photocopy of the book and keep in the rack. That is allowed. But the same circumstances cannot be awarded in all cases. We will come detail when we come to the Indian law, right? So replacement, then preservation, and loaning to other libraries. These are the three rights which are being given under the US Copyright Act. That is replacement, then preservation, for preserving. For example, there are 20 pages are not there in a particular book. You can take a copy of the similar book, 20 pages, and insert into the archiving. I did not tell much about what is archiving to all of you. So replacement, preservation, and loan to other libraries. You can, of course, if you have 10 books, you have the right to give 2 books to another library as well. So these are exempted from copyright violation under the US Copyright Act. Right. Let me now come on to the Indian Copyright Act. The Indian Copyright Act of 1957 primarily focus upon the copyright that is been given to the author. Inside that, Section 2, Clause X, X for Xmas or Xavier. The 2X defines what is reprography. So reprography is basically making copies of a work by photocopying or similar means. So you are reproducing a book or any other copyrighted material in a photocopy. Other means include scan, other means include printing, etc. So photocopying, scanning, printing, all of them comes under the category of section 2 clause X. Whether the reprographic activities are allowed or not will come into section 52 of the Indian Copyright Act. The Indian Copyright Act under section 52 clearly discuss about what is the fair use of a copyright. Now, when we say about fair use, now a person has written a book for lab. I'm going to take an example which I know. So I'm a law professor. So I teach law of crimes. Law of crimes is book is written by Achyutan Pillai. Law of crimes book written by Achyutan Pillai. Now I am deciding this book I can use in classroom. I can use for I can make copies and give to my students. I can circulate among my faculty members for a group discussion. All of this I can do. Now this will be treated as a fair use, but I cannot take a photocopy of book and sell outside the college premises, right? So fair use means whenever any copyrighted work can be used, but will not affect the right of the copyright holder. So that is known as fair use. For example, used by the government of India in the defense sector, atomic energy sector, classroom activities, personal use. Of course, you can photocopy a book, or you can photocopy an artwork, anything which you can use for your personal work. Now, there was a very interesting judgment, M. F. Hussain judgment. What happened was that M. F. Hussain painting was made a photo, color printout, and kept inside an office. The question came is that whether office have a right to take a copy of existing work and keep inside the office premises. The court held that no, it should not be done. Maybe in your home you can do that. So in order to decorate your home, you can take a picture of M. F. Hussain, take a color print of it, and you can label and keep inside your house. That is not a problem. But if you are going to a public place, public access is there. Henceforth, definitely that is violation of copyright, violation of moral right of the copyright. Right. Now, fair use means any work that is used fairly does not affect the rights of the author. So 52 clause N describes what is storing of a work in electronic means by a non-commercial public library. Now, library can be divided into, according to my understanding as per the copyright law, there are two categories of libraries. One is public library, another one is commercial library. So non-commercial public library is where our government libraries in government colleges, all of them are private libraries. We have lending libraries where most of the novels, magazines, comics, you can go and read according to your membership. Of course, I am a member of the Tiruchirappalli Central Library. I paid some 30 rupees as a membership. Membership is different, but borrowing of the books are free. But when I was in Chennai, I used to go to Ishwari Lending Library, where I used to take books for lending. That price is like the rent used to be like 5 rupees, 10 rupees, 15, 20, depending on the price of the book, they used to charge. I have taken books for even 200 rupees when I was doing my master in law. So non-commercial public libraries are one class and commercial libraries are second class. So commercial libraries are exempted from the fair use. They cannot use, they have to purchase the book. But for non-commercial public libraries, you can take a book and you can or change the medium. For example, if it is the book is it's a hard copy, you can scan and keep in the computer as a soft copy. That is allowed. But provided that you have to have the hard copy in your library. Only when you have the book in a hard copy in your library, you can take a soft copy of it and keep inside the computer. That is allowed. But directly, soft copy is not permitted because you don't know the authentication. You don't know the source from where you have taken it. That is the reason. In order to substantiate the source, you need to have the hard copy with you. So let me give you an example. This is the Environmental Law by S.C. Shastri, written. This Environmental Law book runs for say about 600 odd pages. Now this book, you can make it as a soft copy, you can scan it and keep in the library database. That is allowed. That is what section 52 clause N says. Non-commercial public library have the right to reproduce the book in another medium, that is the soft medium. So that can be done, right, for digital purposes, of course. Now section 52 clause O, this is the most important section. Section 52 clause O says that not more than 3 copies of a book in a library. So if any college library or any public library needs to purchase, because public libraries funds are not as liberal as compared to states, because in Tamil Nadu we receive a reasonable amount of fund. My friend Suresh will be very easy to enlighten you about how much fund is being received by most of the public libraries. Of course, Anna Centennial Library is a model library in India, which houses one of the largest library in our country. Now, this 52 clause O gives the right to make 3 copies of any book and keep in the library and stock. Now that is allowed. If it is more than 3 copies, then that is a direct violation of the copyright law. So for library, for the use of library, suppose let me give you a very practical example. See, I have had the privilege to travel all the states in India, starting from Gujarat to Arunachal Pradesh and Jammu and Kashmir to Tamil Nadu. I visited all the states in our country, and out of my experience, I have seen Orissa to be a slightly underdeveloped state. I have been to certain districts like Raigada, Navarangpur, Kalahandi. These are very districts which are very less developed. Now, assume that there is a village in Raigada district, and in that village there is a small library which is housing only 10,000 books. And what happens? The librarian decides to make three copies of each books. Whether that can be allowed or not. Of course, that will be treated as a fair use because prima facie condition, it should be a public library. It should not be a private or a commercial library. It should be a government library or a public library. 3 copies can be done and can be racked in the shelf so as the students can have the right to access. Because we cannot take the perspective only in a city area. We also need to see the students who are coming from rural areas. Poor children who are coming from the rural areas don't have access to good books. So most of the students in the village rely upon only the books which has been given in the school. They don't have a vast or expanded horizon. So all the students need to be focused or need to be tutored to the newer generation or the upcoming generation. So what happens is that it is a responsibility of the every library and every librarian to make sure that the resource is available to vast majority. Most of you who are working in public libraries, you have the liberty to stock up to 3 copies of any book. So that will come under the fair use. Okay, that is section 52 clause O. Now, there are certain do's and don'ts which is recommended by the under the US Copyright Act. That is, first one, purchase from authorized seller. The reason why I'm stating is because if any book is purchased from an unauthorized seller, the question comes whether the right to licensing has been given. I have earlier mentioned, for example, let me take this book, The Environmental, written by S.C. Shastri. It is published by Eastern Book Company, EBC. Now, EBC is the person who has the right to sell this book, so right to publish this book. Now, EBC, what he will do, he will describe the authorized seller from whom you can purchase. If you are going to purchase any book from an unauthorized seller, the question comes about the authenticity of the book or authenticity of the publisher. So it is always advised to purchase book from the authorized seller. Of course, you can directly go and purchase from the publisher as well, and you can also publish from authorized seller, but always recommended that to purchase from authorized seller. And use disclaimer in the reprographic section. In every library, when you have the reprographic section, it is always better to affix a disclaimer. As we in law, we say it as saving clause. You have to mention that the library or the librarians are not responsible for any copyright infringement, because what happens sometimes, the libraries or the books taken from the libraries will not be used for fair use. So it is always better to give disclaimer. Okay. Then e-resource center. E-resource center have now sprung up throughout the country in all libraries. Every college has an e-learning center. Of course, 5 to 7 to 10 computers are placed in every college, and whenever you go to any library, definitely there will be computers for e-learning. In those e-learning as well, the librarian, who is the administrator of the e-resources, should make sure that downloading of e-content should be done in a most secure way and should not violate any copyright. For example, downloading of movies, downloading of photos, downloading of songs, these should not be allowed by any of the administrators. So there should be a restriction on the use of e-resources, because most of the time what happens, because even in our college we face this situation, students come, they sit down, they log into Facebook, sometimes they go and they used to watch YouTube videos. Of course, YouTube has now also become a source for e-learning. Simultaneously, some restrictions should be kept upon the usage of e-resources, right? And next, let me come to contribute. See, while using the e-resources, you need to be specific about the concept known as contributory negligence. Later at a point of time, no library or librarian can come and say that, sir, we have provided e-resources. It is for the student to make profitable. It is the responsibility of the student to make the resources utilization of resources in a studious way. We are not responsible for any act done by the student, because IP law is very clear regarding violation by end users. If suppose if any student downloads a movie, or if any student downloads any music, or if any student downloads by hacking any book or any learning material, If that comes to the knowledge of the concerned author, if he files a case against the library or the librarian, the librarian or librarian cannot say that, sir, I am not responsible. I am only giving the platform for the students. You cannot hold me responsible, because the concept of contributory negligence, because you are also responsible for the act which is happening inside the college premises. So definitely, when we come to the section 52 clause O, you need to be very sure that not more than 3 copies are there, and 52N states that non-commercial public libraries are only entitled to make a soft copy of already existing hard copy book. So following with these do's and don'ts, and by section 52 clause O and 52 clause N clearly discusses and tells us about what is reprographic works. Now, a small personal note which I like to add on is that most of the libraries, what happens is that managing the managing the uses of the library. The uses of library should be encouraged in such a manner that they also, because one more the most important aspect discussed in the Berne Convention 1971 was that encouraging the users in the library, and in the library when the librarian is there, he should advocate the copyright aspects to the users. You should tell about what is the fair use of copyright. Most of the people who come for their dissertation works for a master degree or for MPhil or for PhD, they sometimes opt for other methods. That is by going and downloading from the internet. And what happens is sometimes illegal downloading of content is also possible. So all of them, if it is done in a proper manner, if it is the librarian gives a proper advice and the library is focusing all of the safety measures, definitely there's a good possibility that the reprographic activities inside the library is done in a safe and secure manner. So this is the only area which concerns the libraries and libraries. So Copyright Act is the only such act. Of course, patenting the online, I'm not very sure regarding that. Inside, suppose, let me tell you one example, that in libraries, for example, tomorrow a librarian decides to invent upon a library using method. For example, when I was a master's student in National Law School, Bangalore, there was the system, the OPAQ. There was a system online. I'm not sure about the detail of what is OPAQ. If you type a number of a book, it will show you where exactly, in which rack, in which number the book is available. Now, this system, when it came early, would definitely be a new invention. Now, that can be patented. So you are also at liberty to discover, to invent a new method of arranging books, arranging e-resources. When you do so, what happens is that you can also apply for patent. So with this, I conclude the area as to what is IPR for library and librarians, because the very small aspect where I can tell you legally regarding what are the repercussions of usage of resources in the library. So I conclude. Thank you very much for this opportunity. I am sure because this is not my area of expertise, I could only shed light on only very few aspects of library science. And if possible, maybe I can take few more lectures of what is intellectual property law and various areas of I can do that. But in concerning for library and librarians, this is only small material that I can share with you. So thank you. You are free to